Hello, everyone, and welcome. Thank you for joining Foley and Lardner for today's presentation, Antitrust Counseling for Healthcare Providers. Before we get started, we would like to make a few housekeeping announcements. We will be making a few verbal announcements along with digital announcements that can be viewed in the Q&A box located on the right side of your screen. Please also utilize the Q&A box to record your attendance for today's webinar by clicking Ask a Question and enter your first name, last name, and email address upon entering and exiting the webinar. This is imperative for you to receive CLE credit for attending today's presentation. You must also remain on the line for the entirety of the webinar to receive credit for today's presentation. We also invite you to ask questions during the webinar. To follow along with our digital announcements, please make sure and click the Featured tab and scroll down to the bottom to see the most current announcements. Please note all information submitted through the Q&A box is only viewable by the Foley and Lardner webinar team. The audience will not be able to see anything you input into the Q&A box. At this time, if you haven't already done so, please enter your first name, last name, and email address to register your attendance for today's webinar to receive CLE credit. Please go ahead and type in your credentials in the Q&A box now. Now to review some important housekeeping items and CLE information. This webinar is being recorded for post-event viewing. We will be announcing one CLE code verbally at random during today's program. Please submit this code in the Q&A box on your screen, along with your email address when the code is announced. Please note that if you're seeking CLE credit in Kansas, New York, or New Jersey, you must also fill out the attorney affirmation form that is located in the survey link we will send through the Q&A box. CLE certificates will be distributed to eligible participants approximately 8 weeks after the webinar via email. We will be sending a link to the survey for today's webinar. Please complete it at your convenience. We would appreciate your feedback on today's program. You are welcome to enter questions at any point in the program through the Q&A box along with your email address, and if time permits, the moderators will answer your questions verbally. Lastly, if you have connectivity issues on your Mac, please consider watching the webinar on your iPad or iPhone. And now I will turn the presentation over to Ben Dryden.
Thank you, Lauren, and thank you everybody for joining us today. Welcome to today's webinar on antitrust counseling for healthcare providers. We're very pleased to have everyone here today, and we're especially pleased because today is our first ever edition of what's going to be a larger antitrust counseling webinar series. Mark your calendars. Our next webinar in this series is going to be on December 9th for antitrust counseling for trade associations. So if that's of interest, mark your calendar. And we plan on doing more and more of these. So by all means, if there's any topics that would be helpful for a future counseling webinar, let us know. Shoot us an email. We're more than happy to accommodate. The topic today is antitrust counseling for healthcare providers. As everyone on this webinar knows, antitrust law and healthcare intersect in some very interesting ways, and it's always a fun little challenge to get to counsel a client through an antitrust question in the healthcare sector. I'd be remiss if, in this 2020 environment, if we didn't take this opportunity to thank everyone who's joining on behalf of a healthcare provider. We're mindful every day and grateful every day for those working on the front lines during this pandemic and those who are supporting those on the front lines. So thank you all. We have a great panel today of 3 partners from 3 different time zones. So we're using and making the most of this webinar technology. We're joined by Holden Brooks, who is a partner in our Milwaukee office and in our Washington, D.C. office, which is in Milwaukee today. Holden has a broad antitrust practice that is focused on representing healthcare clients. Her practice spans counseling to mergers and acquisitions to criminal enforcement. We also have Emily Weber, who's in our Denver office. Emily has a diverse national healthcare practice representing healthcare clients in transactions and implementing complex regulations in the fraud and abuse laws, HIPAA, data privacy. She runs the whole gamut. Emily has a particularly unique perspective in that she's not only a law firm attorney, but she has also worked in-house at multiple healthcare systems, including both academic and community health systems. I'm Ben Dryden. I have a broad civil antitrust practice that spans everything from counseling to civil litigation, but I primarily focus on antitrust issues that arise in mergers and acquisitions. Next slide. I have a lot to cover today, but just a couple more housekeeping notes. First, if you have any technical difficulties at all, the first thing to do is try to refresh your browser. If that doesn't work, just close out of the meeting and rejoin. And if that doesn't work, you can email videoconferencing@foley.com and Brian will respond right away. You should have this email address from the materials that were sent to you in advance, but if you don't, you can just take a moment and jot that down in case you have any issues. Second, a copy of today's slides and materials are going to be sent out after the event, but in real time, you can see the announcements under the featured tab in the question and answer widget. Finally, just to reiterate, and this also ties in if you are into any technical difficulties, make sure to submit your full name and email address for CLE credit. And so if there's any snags with that, again, you can email videoconferencing@foley.com. So with that, we'll jump into the meat of today's presentation. Just to give you a roadmap of what we're going to cover, we're going to begin with just a refresher or a primer on the antitrust laws generally, just so everyone's got the same background before we jump in. Then we're going to turn to the real focus of today's presentation, which is special antitrust issues that face healthcare providers. Healthcare providers have, just the industry is more collaborative than other industries. It's got all sorts of complications caused by insurance, interfacing with providers. So providers compete for patients. They also compete for insurance dollars, and that competition looks different between the two audiences. So there's just really interesting issues that face healthcare providers. Next, we're going to talk about mergers and acquisitions in the healthcare context. It's a very hot area of antitrust law enforcement. Then we're going to talk about some best practices to mitigate antitrust risk as antitrust counselors. And then with our remaining time, we're going to look at what to watch for the year ahead, however the election goes in a week and a half. And then as time goes, we're going to have room for questions. But as Lauren mentioned earlier, if you have questions in real time, just use your widget and we'll try to answer them on the fly. So with that, we'll jump into just a primer on the antitrust laws generally. So we go to the next slide. The antitrust laws, and I should say, we're going to talk about today are the United States antitrust laws. There are antitrust laws in something like 125 different countries, but the United States was the first. And for healthcare providers who are usually doing business typically in the United States, it's the U.S. laws are most likely to be the ones we'll run into. A word on terminology, antitrust is kind of a antiquated term that harkens back to when the railroad barons and the oil barons would organize themselves into trusts. So every other country refers to antitrust law as competition law. In the United States, we call it antitrust law. But it means the same thing. Really, the touchstone here is competition. This is law meant to promote competition. I'll read my favorite quote about the antitrust laws. It comes from Supreme Court Justice Thurgood Marshall, who wrote that the antitrust laws in general, and the Sherman Act in particular, are the Magna Carta of free enterprise. They are as important to the preservation of economic freedom and our free enterprise system as the Bill of Rights is to the protection of our fundamental personal freedoms. And the freedom guaranteed each and every business, no matter how small, is the freedom to compete, to assert with vigor, imagination, devotion, and ingenuity whatever economic muscle it can muster. So with that, competition is really what we're talking about here, ensuring that there's fair and free competition in the marketplace. And so there are several different statutes on the books at the federal level. The most fundamental one is the Sherman Act. It's been in the books since 1890 and really hasn't changed very much since 1890. There's two operative sections of the Sherman Act. The first is Section 1, which prohibits agreements that unreasonably harm competition. Sherman Act Section 2 is the other one. It prohibits monopolization This is something a little different than monopolies. We'll talk about that. There's been some other antitrust statutes on the books, the Clayton Act, the Federal Trade Commission Act, the Robinson-Patman Act, that were enacted in subsequent decades, really to reinforce the Sherman Act. But truly, all of these statutes are rowing in the same direction of just promoting free and fair competition. So next slide, we'll begin with the Sherman Act. And Sherman Act, Section 1, jump ahead to the next slide. Section 1 of the Sherman Act prohibits agreements that unreasonably harm competition. So the essence of an agreement is it's two or more different companies or economic actors coming together to combine. And the way the Supreme Court has articulated it, the supreme evil of antitrust law is collusion. That's what they're trying to prevent, cartel activity, price fixing. But the Sherman Act is written much broader than that and reaches, beyond just hardcore cartel activity. Again, the core of Sherman Act Section 1 is prohibiting agreements that unreasonably restrain trade. And an agreement can take many, many, many different forms. It can be a written contract. It could be an unwritten handshake. It can be just kind of a knowing nod and a wink. It can be between two competitors. You call that a horizontal agreement between two companies that compete, or it can be a vertical agreement between a supplier and its customer. It can be between two for-profits, between two nonprofits, from a nonprofit to a for-profit, vice versa. It can pertain to prices that are charged, but it can pertain to many other things like quality or access or geographies. One thing we'll talk about are market allocation agreements, where if one healthcare provider said to another one, you'll get all the patients west of a river and I'll get all of the patients east of a river. That's a market allocation agreement. As we will see, that would be highly illegal. So we can jump to the next slide. Over the 130 years that the Sherman Act has been on the books and interpreted by courts, the courts have identified a handful of really core, hardcore cartel conduct that is deemed to be illegal per se. This is true collusion. Price fixing, getting together with a competitor and saying, this is the price we're going to charge, and these are the terms we'll agree to. We're only going to agree to 30-day payment terms, illegal per se. Bid rigging is another species of price fixing, but bid rigging can take the form of either you'll bid X, I'll bid Y, or it can be you'll win the first bid, I'll win the second bid, you'll win the third bid, I'll win the fourth bid. It's another species of price fixing, illegal per se under Sherman Act Section 1. Market allocation, we just talked about. You get west of the river, I get east of the river. Or there's softer versions of market allocation. You'll get the exclusive right to put up billboards west of the river, and I'll get the exclusive right to put up billboards east of the river. Could be interpreted as a market allocation agreement, in which case it would be reviewed as or deemed illegal per se. Or group boycotts. And when we talk about boycotts, we don't mean a political boycott, like we don't like someone's business practice being unethical. It's two healthcare providers sitting down and saying, we don't like some insurance company, we don't like the terms it's offering in the marketplace. Let's both boycott that company, that insurance company. That would be a per se illegal group boycott. So the next slide, if something is deemed per se illegal, if it's one of these small handful of categories of agreements that are deemed to be per se illegal, then it is irrebuttably presumed to harm competition. And in this hardcore context, there's not only a civil prohibition, but it can also be enforced criminally. People do go to jail for these things every year. So yeah, that's our most important compliance tip. You don't want anyone walking away in handcuffs. Jump to the next slide. So we talked about, an agreement can take many different forms. A lot of times when you're talking about this hardcore per se illegal activity, there's a real question, well, was an agreement really made, or was it just, did things just kind of work out that way? And it's bright line legally, but it can be a very fuzzy line in practice. And oftentimes these questions are decided by a law enforcer or by a jury or by a judge. And so it often behooves companies to avoid entering conduct or pursuing conduct that could even be deemed erroneously to have crossed the line. You might draw the line a couple of steps back from where the line really is, just to add extra protection. That's for the per se conduct. For any other type of agreement, anytime one company enters into an agreement with another company, as long as it's not per se illegal, well, the Sherman Act still applies. You can still review that agreement under the Sherman Act, but the scrutiny becomes a lot less severe. And I'm not making this up. The legal test is the rule of reason, where the fact finder just weighs the competitive benefits of the agreement against the competitive harms. And these can be very, very fact-intensive cases, and we'll talk about some of these cases as we go. Next slide. So the essence of Sherman Act Section 1 is an agreement between two different companies. But Sherman Act Section 2 governs the conduct of a single company just acting on its own. The prohibition in Section 2 of the Sherman Act is monopolization. Doesn't mean it's illegal to have a monopoly. In fact, there's very well-established case law that if you have a monopoly by virtue of having a better product or just being smarter or an historical accident, you have not violated Section 2 of the Sherman Act. But if you have a monopoly by virtue of doing something other than just competing on the merits, if you've deliberately gone out there and locked up rivals or engaged in sham litigation or patent fraud, that's monopolization. And we'll talk about a couple situations in the healthcare context. Anti-steering provisions in contracts or all or nothing contracts sometimes get reviewed under Section 2 of the Sherman Act. I should also say that monopoly for this purpose doesn't mean a 100% market share. It doesn't even mean a 90% market share. It could be as low as maybe 30 or 35 or 40%. When you're at that level, Section 2 of the Sherman Act could kick in. So be mindful, monopoly doesn't mean 100% market share for these purposes. Next slide. We'll talk about mergers and acquisitions in a little bit, but the antitrust laws extensively regulate mergers. There's both the substantive statute, it's the Clayton Act, that prohibits mergers and acquisitions that may have the effect of tending to lessen competition or creating a monopoly. There's also the Hart-Scott-Rodino Act, which is a procedural act that just requires notification to the government before mergers, certain mergers can close. You have to notify the government, give them certain documents and information about the deal, and then observe. It's usually a 30-day waiting period before your deal can close. It's a really, really tricky statute. It only kicks in for deals that are valued above $94 million, but doing the valuation can be really, really tricky. We could spend a whole hour on that. All I'll say is if you're doing a deal that could plausibly result in a valuation above $94 million, you should consult with counsel. Briefly, next slide, just wanted to talk about the players who come up in antitrust cases. There's, by historical accident, two different federal antitrust enforcement agencies, the Federal Trade Commission and the Department of Justice. The two agencies have a more or less established allocation of who's going to do what. So mergers between providers or pharmaceutical companies or medical devices are usually handled by the FTC. Payer mergers are usually handled by the DOJ, but not always. And vertical mergers, if a payer was to merge with a provider, it could certainly go to either agency. Conduct enforcement, if there's a claim that a company has violated Section 1 of the Sherman Act, Section 2 of the Sherman Act, either agency, the FTC or the DOJ, can go after that. But just jurisdictionally, the FTC can't go after nonprofit entities in that context. So if it's a nonprofit issue, it would only be handled by the DOJ. The DOJ has the exclusive power also to enforce the federal antitrust laws criminally. There's also state attorneys general who are very active in many cases in enforcing antitrust laws, especially in the healthcare sector. They can directly enforce the federal antitrust laws civilly, not criminally. But it's also very common for states to have their own state antitrust law that might parallel or even go a little further than the federal law, and the state attorneys general can enforce those state laws. Next slide. There's also other state agencies that often consider antitrust issues. The Massachusetts Health Policy Commission comes to mind. State health boards when they make certificate of need type rulings, and then private plaintiffs. It can't just be any stranger off the street, but someone who's plausibly able to say that they're going to be harmed by an antitrust violation can file a civil lawsuit to enforce the antitrust laws. And that's how you get these massive class action lawsuits that can go on for years and years, and they're some of the biggest cases in the country oftentimes. The private enforcement is actually very common. The next slide, just wanted to briefly say that promoting competition in healthcare markets has long been a top law enforcement priority for the DOJ and the FTC and state attorneys general. Got a quote from the FTC chairman last year who was talking about this. And it's something, on the margins, Republicans are probably more laissez-faire than Democrats, but, in terms of the desire to enforce the antitrust laws in the healthcare sector, we usually see some pretty bipartisan support for that. So we don't expect major changes no matter how the election goes in a couple of weeks. Next slide. With that, I'm going to pass the baton over to Holden, who's going to talk about really what we're here to talk about today. You're on mute, Holden.
Sorry about that. As Ben said, I'm Holden Brooks. I'm coming to you live from Milwaukee today, our historical headquarters. And I do about 90 to 99% of my work is in the healthcare antitrust space. I'm really pleased to be here today to talk to such a great diverse audience coming to us from many different sectors. And I'll try and put something in here that will be of interest to everyone, whether you're on the payer side or the provider side or the compliance side. All right, if you could move to the first slide. All right, so clinically integrated networks. What I'll say about clinically integrated networks is no one means the same thing when they use this term. It used to be, going back to the 90s, that this referred to a collaborative effort among providers, usually in the same community, usually in something like a PHO structure where you had a hospital and you had specialists and you had primary care physicians who wanted to come together and essentially function as a healthcare network and offer themselves to payers as a through one contract as a network who was going to work together and provide coordinated care and integrate a system of carrots and sticks that would require the providers who were working in this context to be working towards common goals. And you could be kicked out or fined or whatever if you were not hewing to the policies and procedures that were designed to improve care and the efficiency with which that care was delivered. The standard in that kind of classic clinically integrated network with respect to how the antitrust enforcers looked at it is that they were fine with this joint contracting, which otherwise would have been a per se violation of the antitrust laws, as Ben explained. They were fine with this joint contracting among providers who would otherwise compete or were potential competitors with each other, as long as that joint contracting was reasonably necessary to achieve these quality goals and efficiency goals and, population health initiatives and all of the other positive things that can come out of collaboration. There needed to be a solid case that you needed the joint contracting and the financial carrots and sticks in order to achieve those goals. And going back in time, there have been plenty of organizations that have gotten essentially a blessing from the Federal Trade Commission to go ahead and operate as a clinically integrated network. So this is providers who are maintaining their independence but are working together and jointly contracting in this very narrow circumstance where they're offering something new and better and different to payers. New, better, and different because they're going to be working together. The goal has to be that you really are motivated by efficiency improvement and quality improvement. And over time, the FTC has really learned how to tell the difference between providers who just want the benefits of some leverage with payers and this, transaction efficiencies associated with joint contracting, and those people who really do have a goal of improving care. As it says on the slide, just having a single electronic medical record is not enough. Just having shared back room or back office functions is not enough. And I will say that there's plenty of times where we've been approached to help a provider client explore establishing a clinically integrated network. And when they find out how much work is really involved in creating the infrastructure and the committees and the analytics involved in trying to measure your progress and set your goals on an annual or regular basis, as soon as they find out that there really is a significant amount of work involved in that, they tend to, in some instances, sort of hit the pause button. So if someone comes to you in your organization and asks you to join or asks if you're interested in starting a clinically integrated network, and it turns out that this is what they're talking about, this classic clinically integrated network, your first call should be to an antitrust lawyer so that everyone understands the realities. Because if you go forward without an understanding of how the antitrust laws apply to these arrangements, you can get in hot water. Again, this kind of joint contracting that is not reasonably necessary to give rise to these efficiency and quality benefits can be deemed per se unlawful, and then you're really in some hot water from an antitrust enforcement perspective. Next slide. All right. As I said, not everyone means the same thing when they use the term clinically integrated networks. We also are approached quite often by clients who say, we want to do a clinically integrated network that will bring together many different healthcare systems in our state. Clearly, those systems, to the extent that they are operating in different territories and different parts of the state, they are not going to be integrating care in the same way that we see in the classic clinically integrated network in that sort of PHO model. What they're really talking about is a network usually that involves sharing best practices, making common investments in an EMR that will allow them to share information about patients to deliver coordinated care to the extent that some of these systems have tertiary services that others don't, and so on and so forth. Usually that is a very different antitrust analysis because obviously those systems are not in a position to compete with each other. At the same time, there is not as compelling a case with respect to quality and efficiency improvements. So I think the headline for clinically integrated networks as a takeaway is if you're approached by a business person or another provider in the community about doing this, find out what they mean. Take stock of whether you are a direct competitor with any of the people who will be involved in this network. Ask what the plan is for joint contracting, because quite honestly, I, with some frequency, get calls from provider clients saying we've been invited to join a clinically integrated network. I say, is there joint contracting involved? And they say no, that it really is much more of a loose affiliation that has no joint contracting or joint price setting involved, in which case the antitrust risk is very low. So these take many different forms. the antitrust analysis is very fact specific. So again, first call when somebody proposes a clinically integrated network is to your antitrust lawyer to get a little bit of high level advice for understanding how to move forward. All right, next slide. All right, along with clinically integrated networks, we also see, a lot of innovation in the last 10 years or so with respect to provider collaborations. There's been, a real recognition of the value of collaborative care in a provider community. I think payers are seeing this. I think that, systems are putting a lot of energy into looking at how they can better work with independent community-based practices. But all of those multi-provider collaborations should be viewed as having potential antitrust issues associated with them. This is, your JVs, your GPOs, any kind of co-branding or marketing arrangement, exclusive or professional services agreements, and as well as joint operating agreements or management agreements where you're bringing together providers in a sort of a business structure, even though they may be operating business as usual. They will be under an umbrella of some kind of governance organization. Again, this analysis is super fact dependent. And it really depends, like the clinically integrated network concept, on what you're trying to do. Are you trying to improve care? Are you trying to improve the efficiency of care delivery? What are the upsides of a collaboration? And how do they balance out against any diminishment in competition that may be associated with this arrangement? So, for instance, if there's a professional services agreement that's entered into, and there's a non-compete associated with that PSA, that would usually be analyzed, as Ben said, under the rule of reason. You look at how is care going to improve under this PSA, you look at the non-compete, you look at the degree to which competition is being harmed, and you balance those out. One note on this slide, I think we're going to be getting into it a little bit more later, is the closer that a collaboration comes to resembling a merger, the greater scrutiny it will have. The more head-to-head competition you have that is affected by whatever this collaboration is, the more scrutiny it will get. One thing, again, that sometimes when clients inquire about a JV or some kind of collaboration, if they come to understand that there will be limitations on how they can communicate and collaborate with their partner in that collaboration. For instance, if they realize they cannot exchange managed care contracts because there's competitively sensitive information, sometimes that will, that idea becomes less appealing. So I will just say that, again, involving antitrust counsel upfront can save you a lot of time and money. It is not uncommon that parties get pretty far down the line in planning for something like this before they involve antitrust counsel, and once they realize the realities of a competitor collaboration, it's less attractive than it once was. But these have great potential, and we do a lot of work in this space, and this is obviously the future of healthcare, and we hope people keep innovating in this area. Next slide. Payer contracting. I have to say this is an area that is undergoing a lot of change. I think there's not a lot of clear guidance on the payer side and the provider side for what the expectations are in this area. And I think that the next few years will probably give us some case law and enforcement actions that will give a little better practical guidance to people in the market for how to think about antitrust in the context of payer contracting. Right now, there's a lot of focus by private plaintiffs as well as federal and state enforcers on the provisions in managed care contracts that restrict how a payer can steer or tier providers and also the restrictions on a payer's ability to exclude a provider from a contract. This is the sort of narrow network, tiered network concept that has been, a real source of innovation on the payer side for a long time. Obviously, there's some insecurity on the part of providers when they think about getting the benefit of their bargain. How do we make sure that we are going to get sufficient volume and commitment from this payer and, sufficient level of covered lives coming through our doors to justify the pricing that we're given? I think that this will play out in the next few years, but it's definitely an area, again, to involve antitrust counsel in early, particularly if there's a core antitrust issue that comes up in the context of negotiations. Better to address it there than to have it litigated or investigated later on. Next slide. All right, this is just an example of a DOJ enforcement action in 2019. The North Carolina AG and DOJ pursued an enforcement action against what's now called Atrium Health. It was called Carolina Health System at the time. The allegation was that they had a very high market share in the Charlotte area, and as a result, had to agree to conditions on what they could and couldn't do, again, in this area of tiering and steering. Next slide. Another, very high-profile litigation in this area was Sutter Health, the California AG, and again, a private class pursued action against Sutter Health. Again, making allegations about the contracting practices with respect to having to take facilities and services and providers that a payer did not want, having to put those in network in order to get some must-have facilities that Sutter had in Northern California. The headline here is that the settlement was $575 million, and what ended up being some pretty onerous conduct remedies on what Sutter can and can't do going forward. Next slide. Again, if anytime there's a restriction on admitting privileges, this is a classic antitrust issue. Call your antitrust lawyer when someone starts making noises about this. It is something that has led to a lot of litigation in the past and can bring up a lot of different antitrust issues. Next slide. I'm kind of moving through these because I need to pass the baton here. All right, one really important thing to understand, because it's something that I think is a blind spot for a lot of not just healthcare providers, for everyone who's an employer, is that your agreement not to compete as an employer with respect to what you're going to pay people, how they're going to be compensated in other ways, what your recruiting and hiring practices are going to be. Those agreements and that conduct is also subject to very serious antitrust scrutiny. This is an area that the agencies have been particularly focused on in the wake of COVID, because as you can imagine, particularly in healthcare, there's been a lot of issues regarding, staffing and compensation of medical professionals like nurses, et cetera. This can be, the DOJ has signaled that they will pursue this criminally. Again, this is an issue to take very seriously if it comes up in the context of any of your business. Next slide. This again has played out specifically in healthcare within the past couple of years. The Department of Justice Antitrust Division took action in a private lawsuit regarding an agreement between Duke and UNC not to hire each other's medical school faculties. It was a very protracted, serious case, and I think is a real, should be a deterrent to anyone in the healthcare space from maintaining this kind of a agreement, even though it seems collegial, a gentleman's agreement, maybe something that's been in place for a long time and may have some what seem like obvious business upsides. It's still per se illegal, and the DOJ has taken a very hard stance on this. Next slide. The other thing we want to stress is that one thing that's happened in 2020 is that for the first time since 1990, the Department of Justice Antitrust Division took criminal action against a healthcare provider. In April, a physician practice in Florida resolved a criminal action with DOJ for the statutory maximum of $100 million, with a separate $20 million payment to the state AG. And just recently, the former head physician of that practice was indicted by Department of Justice and will face a criminal trial in December of this year. So that's a new development. Put an asterisk by this with respect to, when you're pitching for greater antitrust compliance in your provider organization, or, frankly, any healthcare organization. Just know that although there has been some sense that there's been some exceptionalism going on with respect to criminal enforcement, antitrust enforcement in healthcare, that exceptionalism no longer exists, and they are very focused on healthcare on the criminal side at DOJ. Next slide. All right, Ben, I'm going to hand it back to you.
Thank you, Holden. That was fantastic. I'm going to discuss. Okay. Going to discuss mergers and acquisitions in the healthcare context. Before I get to that, someone asked a question. It's a very good one. What is the difference between a no poach agreement and a non-compete? It's a good question. This actually comes up all the time. The guidance that the DOJ and the FTC put out, the written guidance isn't extremely clear, but they have subsequently kind of clarified their guidance that, a non-compete agreement, if you're, entering into a contract with a staffing firm or a consulting agency, or if you're buying a business from someone and you've got a reasonable non-compete clause that you can explain legitimately supports the entire collaboration, that gets reviewed under the rule of reason and should, depending on the facts, should survive rule of reason scrutiny. The criminal element comes in where it's just a naked, and naked is the technical term, a naked no poach agreement. Two companies say, let's not cold call each other's employees, or let's not poach each other's employees. That's where, according to the guidance, the criminal line would begin to cross. But it's a fact-dependent question. It's a very good question. So with that, we'll turn to mergers and acquisitions. We could literally spend all day on it. I've got a whole book on antitrust issues and mergers and acquisitions for healthcare companies, but we'll do this real quick. So we talked about the Clayton Act prohibits mergers or acquisitions that may have the effect of substantially lessening competition or creating a monopoly. And there's case law. I've got a quote here that the word may is a significant one. Doubts are to be resolved against the transaction. So it's when you're on the defense side trying to justify a merger, the government doesn't have that huge of a burden of proof to try to stop the deal. So that's where we're starting with. The next slide. This is just an absolute hotbed of antitrust enforcement activity. Not just is it a hot issue for healthcare providers, but in all of antitrust law, this might be the ripest area of enforcement activity. I've got 6 cases going back just in the past 5 years where litigation was filed to stop a provider merger. And you can say, going back to the year 2000, the federal government has not lost a litigated merger challenge. It's seeking to challenge a provider merger. They haven't lost any on the merits. There's one case I'm aware of, and I'm aware of it because Holden and I both worked on that case, where it was a merger West Virginia, where the FTC filed administrative litigation to stop the merger, and then the state of West Virginia enacted legislation to regulate the parties some other way. And the FTC said, okay, in that situation, if the state's going to regulate it, we'll back off. But that, that's the high water mark of defense side success, in this century. The government brings these cases a lot, and they tend to win them. Next slide. I just want to talk about the issues that usually come up in these cases. One issue is just how the markets are defined. It often turns on how you define the geography, because if the relevant market is a small geography, that makes the government's case easier. If it's a large geography, it's a harder case. But there's not really a rhyme or reason to how the government draws geographic markets, and they'll do two very different approaches in back-to-back cases, and you just have to roll with the punches. Product market definitions aren't usually as litigated, but what's interesting about product market definitions is the government's really focused on how mergers will harm the competition for the provision of services to commercially insured patients or to commercial insurers and their insured members. The DOJ, the FTC assume that, if a patient has Medicare, has Medicaid, that those agencies are able to negotiate fair prices. They can protect themselves. It's kind of interesting to see as we go forward, just, as public, if a public option becomes a thing, if single payer becomes more and more of a thing, just where they're going to draw that line. Next slide, just the other issues that come up. I touched on this a moment ago. The state of West Virginia passed a law allowing the state to review a merger, and they issued a certificate of public advantage. We're seeing more and more of this. There are states that, if they clearly articulate a state policy that they want mergers to go through, even notwithstanding any harm to competition, because they see other benefits in them, and the state creates, further to that clear articulation that state policy, the state creates a regulatory system to actively supervise parties and hold them to their agreements. The antitrust laws stop there. States are sovereign entities, and they can make those decisions. And so we're seeing more and more mergers that would have been stopped by the FTC get through because the state issues a certificate of public advantage. Another defense that comes up with some frequency is the failing firm defense. If a provider is going to go out of business and there's no one else that's willing to take them on, then the government will let that merger through, but there's several hoops you have to jump through. So if that's you, involve counsel early, because those are very complicated cases. The government will also look at, are there other benefits? Are there cost reductions? Are there quality benefits? I think I said earlier, if you can show that you're going to save lives, then you're probably going to win. But it's a matter of, you have to really show that this merger is necessary to creating some clinical benefit that's going to lead to a saving of lives. And then the government will really look at, what do people think about it? What do the parties' documents say? They put a lot of stock in, even low-level employees, just internal emails chattering about how they view competition. Then finally, just the process. I talked about that you have to notify the government if your deal is valued above $94 million. If that's you, and you notify the government, and the government has issues with your deal, they'll issue what's called a second request. Technical term is a request for additional information and documentary material. And that has the effect of extending the waiting period until you've complied with the second request. And compliance with the second request can take months and months and millions of dollars, and it's a real big ordeal. So if you're going down the path of, you have a deal that could get some antitrust scrutiny, it's going to be HSR reportable, even if it's not going to be HSR reportable, loop in counsel as quickly as you humanly can. Counsel will make all the difference in the world. So with that, I'm going to hand the baton to Emily, who's going to talk about some practical tips.
Right. Thank you very much, Ben. Joining you from now very cold Denver, Colorado. It's been very warm, and now I think it's going to snow. But I'm going to go through this extremely quickly because we have 2 more sections and 10 minutes left. But we're just going to talk about, the top 5 practical tips, and I think it is sort of at a minimum. We've heard today from Ben and Holden, if you have a question, involve your antitrust counsel at the beginning. It can save a lot of time and a lot of money. So one of the first questions is, and one take home is your compliance training. And in 2019, the Antitrust Division came out with a guidance document about what should be in a healthcare entity's compliance program. And there's 9 elements. I would encourage you, or you can reach out to us and we can send it to you to read through that guidance document. But really the 9 elements talk about, design, culture of compliance, resources dedicated to antitrust compliance, risk assessment techniques, the training and communication to employees. Of course, there's always monitoring and auditing. And then reporting, incentives, and discipline, and then last but definitely not least is remediation. So this is something that really any entity and a lot of our healthcare systems and payer clients and friends should really consider having if you don't have already. And that DOJ guidance really is helpful because it goes through what you need to have in place. And I think it doesn't need to be overly complicated, but having a policy in place will really serve you well with the DOJ and can if you have an issue, can lessen any fines. Next slide, please. So this next one is your interactions with competitors, and really how are you and how's your company interacting with competitors? Who's interacting with competitors? How are they doing it? In what forums? What are they talking about when they do that? And one issue to consider is for those employees that interact with competitors, it could be, I think oftentimes, and this is just me reaching back to my in-house years, it's individuals in marketing, in strategy, and oftentimes in your physician relations groups and sort of your outreach groups. How are they interacting with competitors? Ben, if you can very quickly talk about the noisy exits aspect of this.
Sure, very quickly, picture a trade association meeting where you get together and you're talking about legitimate topics, and then suddenly someone in the room says, we should boycott some particular payer because they're squeezing us. At that point, the trade association has crossed the line from a legitimate meeting among competitors to talking about something that's per se unlawful. And so, you need to train your people if they're going to be in a position to, suddenly have a conversation, take a left turn like that. You have to train your people how to make a noisy exit so they can stand up and say, guys, I can't have this conversation. I'm leaving. Just so that there's never a question after the fact whether you joined or not. And we're seeing, in COVID with more and more remote meetings and virtual conferences, these issues get very interesting, how to really do an artful, noisy exit. But that's the short answer there.
Great, thank you. And actually, one thing I wanted to note, especially when Holden was talking about the payer contracting provisions, is I've been working a lot on the price transparency rule that's supposed to be in effect on January 1st, 2020. So I think it's how do you reconcile the antitrust, desire to sort of limit, promote competition and not share information such as payer contracting rates and that kind of sensitive information with all of this price transparency rule, which basically says you have to provide all of your negotiated rates. So I don't even know how that's maybe for another CLE, but I don't know how those two reconcile. It's a hard one. Okay, next slide. So our next one is about JVs. And so I would encourage you to look on this, but the slide, when you have time, but your JVs, your JV can be your competitor, and there's a lot of antitrust issues when you JV an issue. And so one issue to look at is, what are the conversations and communications that you're having with your JV partner? Don't let a legitimate discussion bleed over into a broader discussion. And this is really an example where you may have 2 physician groups that are JVing to create an imaging center. There's a lot of, very legitimate patient care purposes for doing that, to provide, a lot of very good equipment to a community that could otherwise not have it. So when you are discussing, when your executives and your employees and your finance people and your strategy people are talking about this JV and entering into it, and certainly even after it, you want to make sure that you're talking about legitimate purposes and furtherance of the JV. And, I always say stay on the side of the angels and talk about, patient care issues, quality issues. Don't bleed into talking about, hey, you know what, whether it's in a meeting or quite frankly, off on the side after the meeting in the hallway. Hey, we've been having this issue with this payer, or we've been having an issue with this rate. Don't talk about that. Be disciplined in what you talk about and what you don't talk about. Okay, next slide. Due diligence. Again, this is really important when you're engaging in your due diligence. I think it's worth talking to your antitrust counsel, even if it's just for 5 minutes. Those are good 5 minutes to say what can we and can we not talk about, and really making sure that you have the right people looking at the due diligence. At the due diligence documents. You could have a third party look at it. You could also just have some person or group in your organization look at all of the documents that really isn't involved in the arrangement, or that really has no interest in it, and there's sort of an independent party that can look at it. That's certainly a more cost-effective way of doing that. And last but not least, the 5th slide is about document creation. And I think probably all of us, more than anything, we look at issues and advice because you do not want to be on the front page of a newspaper, except for very good reasons. So, as we say here, everything comes out in an investigation. Oftentimes I see this all the time with fraud and abuse issues, and I would assume it's the same often with antitrust issues, is that one of the first things that the government will ask you to do is to waive privilege. So you want to make sure that what you have is something that you would be comfortable saying in front of a judge or any regulator. So really everything does come out. So understand the rules about attorney-client privilege. Don't have bad paper. Don't have bad emails, right? Like everything does come out. So we want to make sure that everyone stays on the front page of the newspaper for good reasons. And so that we have 2 minutes left. So I'm going to hand it off. I think we actually have our CLE code right now.
Correct. At this time, we'll announce the CLE code. For those of you seeking credit today, please type the 5-digit code into the Q&A box with your credentials and hit send. The CLE code is I1Y2. Again, that is I as in Ida, another I as in Ida, the number 1, Y as in young, and the number 2. Please make sure you enter the code into the Q&A box along with your email address. One last time, the code is I as in Ida, another I as in Ida, the number 1, Y as in young, and the number 2. And now I will turn it back over to our presenters.
I'm going to go through this so fast. This is what to watch for in 2021. A lot of these things will be the subject of additional programs throughout the year, and we'll look forward to having you back. Can you go to the next slide? Number 1, as Ben said, merger enforcement is very hot right now with respect to the FTC and DOJ on the payer side, on the provider side. There's a contested hospital merger that is playing out in a courtroom in Philadelphia right now. That's something to watch. Also, we see a trend towards minority investments in the healthcare provider space that we see the enforcers willing to investigate and challenge as well. Next slide. This is an enforcement priority for both Republicans and Democrats, and we expect that there's going to continue to be some enforcement energy in this space, regardless of who wins in a couple of weeks. Next slide. State AGs definitely in on the action as well, particularly in states like California and Florida and New York. There are whole healthcare shops for antitrust set up in state AG offices. We see them targeting healthcare, again, on the payer side and the provider side as a place where they can really make their mark. And we would expect to see more and more involvement of state AGs. Next slide. State action immunity, commonly misunderstood concept. Again, if a business person comes to you and says, we want to do something covered by state action immunity, call your antitrust lawyer, make sure that everyone knows what they're talking about. This is a doctrine that says that essentially when you're doing something, if you're a private party authorized by the state, then you're shielded from the antitrust laws. It's a much more narrower source of protection than many people think, and it's one that the FTC in particular has a great interest in. Next slide. So there is a lot of action in Congress right now around all kinds of aspects of antitrust, but one of them is some legislation that would narrow the traditional McCarran-Ferguson Act exemption that covers the business of insurance. This is still playing out in Congress, and again, is something to watch. Next slide. All right, 2 minutes over, but I think we're free to take questions if anybody has any.
We are not immediately hearing questions, so with that, I think we will wrap this up. Thank you all for attending. I hope this was informative. If any questions come up after the fact, please do not hesitate to email us, and by all means, look forward to more antitrust webinar counseling, antitrust counseling webinars going forward. Thank you so much.